Please, Your Lordship. My Lord, I beg to make a mention of item number 5, hearing list for the respondent.
Number 5?
My Lord.
What's number 5? My DV?
My DV, Your Lordship.
Where's the other side?
I'll inform, Your Lordship.
You informed them?
I will inform, my Lord.
No, you informed them. When?
2 weeks' time, my Lord.
Yes, okay. You inform them.
I will.
If not, they won't come. Right.
Obliged.
Obviously. Hi, Sean.
Best for affidavit.
After it's filed?
Not yet filed.
I have not received.
Some
It's not been filed. How will you receive? Yes, what to do?
Taken some time, my lord. One more.
Mr. Sahu,
Yes, let them file.
let them file. Very good. As prayed for how much time?
3 weeks time.
For the 3 weeks time allowed to the respondents to file paperwork. Any interim orders?
No.
Yes.
Hearing, item number 4.
I Arulai.
Yes, Your Lordship.
Is still pending the Supreme
Yes,
Court?
Your Lordship.
What is the next date?
The next date is on 23rd September, Your Lordship.
23rd September.
Yes, Lordship.
This matter can't be taken up independently.
They've gone against that, my lord.
What to do, Mrs. Nathan?
With this order.
Same order is.
On the quantum.
Even we went to Supreme Court on a point of.
On the point that, because there's a circular from the Customs Department fixing
Pecuniary level.
my lord.
But then you've taken a policy decision on that.
Those were GST matters, my lord.
Oh. Okay, Mrs. Naitang's praise matter will sit after 6 weeks as a matter is pending consideration before the Supreme Court. Yes. That's it. Then time becomes 10 minutes.
Any mention?
Lordship, I beg to mention item number 39
Yes.
of the hearing. This is the matter may come up after 2 weeks, Lordship.
Yes. Which item?
39.
Whose other side?
No objection.
No objection. Yes.
Item number 36.
Yes. Barshila Sangma.
Yes, Lordship.
Yes.
This is a revenue matter and it's a dispute between mother and two daughters. Now, before we take up the argument, I was thinking that if it
Mediation.
can be referred to the mediation
I have no objection, my lord.
and
Now for
so
a
that
district
some
council.
solution can be found. If not found out, then we...
You do one thing, just after the orders, we'll upgrade it. And you kindly be here, Mr. Jindal.
Which one, sir?
We will upgrade it. We just finish with the orders and then we upgrade the hearing matter.
After the orders, the matter will be taken up.
Or your junior can be here.
Yes.
Let him be here. We'll call it out.
Supplementary list item number 1.
Yes.
Please, Lordship. Lordship, here, this petitioner, he is a resident of a particular Nongal.
He is a?
Resident of the Nongal Bibra.
Nongal Bibra.
Yes. Now, what happened is somewhere in the year of 1977 and 1978, the land had been acquired by the
1978.
Yes, 1978 and 1979, some portion of land had been acquired, and then this is admitted by the state respondent that they have supposed to pay some, they have paid some amount, but then they supposed to pay remaining balance amount. Therefore, in their letter, they have repeatedly stated that since handing over of the land and final settlement between the Akung Nokma and the private respondent have not been done. Therefore, it has been since from 1978, and then it is their admission that they have some due has to be paid, and then since they have not cleared the balance amount, the final settlement have not been done, then land have not been handed over to the private respondent. Now it has been, then the private respondent have the state respondent have not pursued in paying the amount to the landowner.
So they was not taking over possession when the
No,
was
it is
acquired.
the-
Where's
Yes, Lordship,
the order
yes.
of where's the notification?
Page 36, my lord.
Notification acquisition.
Yes, page 36. They have mentioned there, or again repeatedly, even.
No. Where's that notification? You see, a land's been acquired.
Yes,
Is the schedule mentioned there?
Yes, that is the page 36, my lord. It is
It's mentioned there. What is
they have
the
mentioned,
area?
Yes. Area, because the boundary area they did not mention.
Where's the notification?
I'm taking you to page, because the land was not taken as per the Land Acquisition Act. It was the company, as per companies, they have mentioned there, company acquisition, Land Acquisition Companies Rule 1963. Because they have.
Okay, yes. No, that's fine.
Yes.
There's still the own acquisition act also.
Yes.
Yes, where is that?
Yes, Lordship, I'm taking you to the page 36, my lord. Yeah, they have mentioned the history of the.
No, where's the description of the land?
Description of the land is.
Or the area?
That is not there, but however,
Then how do you know?
No, Lordship, now I'll take you to the imperial letter issue. We are agreed by this order, that's why we are coming, Lordship. Page 54, my lord. That is the issue letter issued by the
54.
Energy Corporation, 54. This is the letter. After 40 years, they are issuing this notice. And we have been settling there, and the land has not been settled over. May I read this? We are agreed by this, particularly we are the resident, we are agreed by this letter, your lordship. Now in this letter they are saying that telling the deputy commissioner that we have to be evict, they are saying that we have to be removed, the petitioner and the landowner. Now
how many of you are there?
We are 174 petitioners.
Yes, who's appearing for the MECL or for the state?
And for the state.
Yes.
Just 1 and 4.
Where's the issue note? Will issue notice?
Lordship.
But, Your Lordship,
Yes.
if I may, at page number 51. This is a typed copy of the letter which is dated 5 July 1978 Page 51, my lord. This is a type copy. May I read, my lord?
Yes or no? It's not necessary.
No, so my
Because the
lord,
thing is that you're referring to 78 document.
Yes,
what
but-
is the status of the
Let them
we'll have to
get
get
an
lord,
instruction
the
and find
no,
out.
my
Well, we see one thing, MS Bank, is that the MECL is, where's our colony?
not here, my lord.
She is standing counsel for MECL, correct?
Notice me. Go, let them file the affidavit.
But my lord, if I may read,
Yes.
if you don't mind, my
No,
lord,
no,
at page
it's
number
fine. That is, I've seen that letter just now.
No, but the letter says that the compensation has been paid to the district court. I mean, district council. Sorry, my
That
lord,
is a
district
part of that
council.
one only.
In 1967, so they're not made parties here in this writ petition.
No, that, see, whatever has transpired or happened, then the MECL is the best authority to say whether where the description of the land, whether they paid compensation, whether they refused to vacate, that necessitates this eviction notice. Yes, I've heard Mr. P.T. Sangma. But then, yes, Mr. R.K. generally appearing for MECL.
Miss Olivia is also assisting me in this matter.
No, I'm talking about the MECL.
There's a
Yes, not she is authorized. We'll get you back.
MECL also.
okay, my lord.
I mean,
Respect note number 2 and 3. MECL is 2 and 3.
Okay, 2, 3, 3, yes.
1 to 4, my
And
lord.
who's appearing for the state?
And we're also appearing for the state, my lord.
You can't, they're two separate entities.
Then my
I request one of my colleagues to appear with you.
Yes, heard Mr. P.T. Sangma, you should notice this, the Archival General along with MSOA banks present accepts notice of behalf respondents 2 and 3. Any government counsel 2 and 3, no further notice to respondents.
Mr. Sheikh.
Yeah, Mr. Sheikh accept notice behalf of respondents number 1 and 4. Such notice complete. Stop. Where's your prayer?
Yes, no, that's prayer page. 27, madam.
Yes, the petitioner is before this court being this letter 18/11/24.
Yes, lordship.
Now you come now.
No.
So no danger of any immediate eviction.
18/11 recently.
Eviction
then
notice.
we file a representation before them.
That is the eviction.
Next week, my lord, next week we will get the instruction. Lordship may have this matter next week so that we will get the
Yes, if you notice so and so. The subject matter issue, it appears, is with regard to an eviction notice served upon the petitioners who allege that they have the response 2 and 3 are seeking the eviction from land belonging to the corporation. Stop list after 1 week
Lordship.
for instructions, yes.
Lordship.
Daily list item number 1.
May it please your lordship, madam, first of all,
Yes.
madam, one miscases there 78 of 2025 for craving leave of this honorable court to accept my sir rejoinder, which was filed, my lord, on
That is item number 11. Item number 11. An application has been filed, Lordship, seeking leave of the Honorable Court.
Okay, yes. Okay, you take the miscase
FCI
78.
has filed.
Yes, Mr. Singh.
Yes, madam, that application 78 of 2025 for craving leave of filing of the one sir rejoinder against the affidavit.
Why?
No.
Why do you need it to?
Madam,
Why you need to
because
file it?
on one occasion it was submitted that the affidavit has been completed, my lord, exchange of
Yes,
affidavit.
yes.
So they might take objection. That's why by
You already filed rejoinder also. Yes,
No objection to this.
Miscase now 78. Yes. This is 78 in WPC number 19/2025. This is an application seeking leave for filing a sir rejoinder filed by the for taking on record a sir rejoinder SUR, then rejoinder filed by the respondents against the affidavit reply the petition of the petition stuff. Mr. B.K. Singh submits that the same is necessitated by the subsequent developments that have happened in the case stuff. The same objected to by Mr. Upadhyay. Accordingly, the miscase is allowed, so rejoinder to be taken on record. Miscase stands as disposed of.
Now the matter may come up after a week, Lordship, for hearing.
Yes.
My lord, there is an urgency, my lord, in this case, my lord, because the validity of the tender is expiring on 22/5, my lord.
20?
Next week, my lord. So 22/5, my lord. So my lord may fix the matter on 28th of May, my lord. 2005.
Okay. Based on 20th main matter.
Interim may continue, Lordship.
Interim order any shall continue.
Highly obliged, my lord.
Item number 2.
Praying for further weeks, further 1 week time, my lord, to file my rejoinder.
How many times you've taken?
This is the second time, my lord.
You're taking first steps on this number 4.
My lord, first step, my lord, we have prepared it, we have to send it today, my lord. I mean, we have obtained the copies from the registry, my lord, we will send it today.
The office note says you not collected the notice from the registry.
Lord, we forgot,
Forgot, it's come out from, it's not fine. Yes, what happens. Yes.
I am for the file.
Yes, yes, Mr. S. Thapa has submitted due to inadvertence, the steps could not yet be taken for number 4. He prays funds allowed for the, he prays for is allowed to affect the same within 2 days. Stop. Rejoinder?
Praying for a week's time, my lord.
Yes. He further prays for 1 week's time to file rejoinder. Prays allowed. Just after 1 week is.
Item number 3.
This is my lord.
Section 19
You brought authorities.
My lord, I have some authorities.
It's very interesting, this point.
Interesting, my lord. Ultimately, the end of the day, my lord, the question is whether there is a source of power under the Act.
Right.
So there are a decision, my lord.
Right.
It doesn't matter,
Right,
my lord,
right.
whether referring to
under section 19, the source of power is there to suspend. Or under section 19 is only to temporarily suspend, temporarily take over the administration until normalcy is restored. Then it comes back.
Exactly, my lord. I'll satisfy your lordship.
We'll have at the end of the report.
Yes.
Item number 4.
Please, your lordship. Lordship, we're praying for.
Yes?
We're still awaiting instructions, your lordship.
What's the matter about?
This is contempt, my lord. On the earlier occasion, we were asked to, there is a direction to regularize my service, and then time was given 6.
Have you served respondent number 2?
Yes, we have served it yet to be received. Service notice is still awaiting.
Yes, MS Ailingwa prays for the 1 week's time, submitted by Mr. P.T. Sangma also. Status of service on respondent number 2 is yet to be obtained. List after 2 weeks.
Lordship.
Obliged, lordship.
Lordship.
5.
Yes.
Lordship, we are doing appearance on behalf of the respondent. We may be given some time to.
Sole respondent.
Sole respondent.
Yes, MS T. Yangi B. EAG with Sunso. It's an appearance today on behalf of the sole respondent. Stop. She prays funds allowed 2 weeks time to
2 weeks time to file affidavit. Obliged.
6.
Your lordship, this what I got instruction is that respondent number 2 has been transferred. Your lordship, I maybe just allow.
Who has been transferred?
That which I have already asked a respondent
Contempt
number
is
2.
by person.
Yes,
You
person.
can add a party.
Now he's transferred something that is defect because.
What defect is there?
That name of that respondent number 2 is no more.
Okay.
So I may be allowed to withdraw, so I can file a fresh.
Yes, sir. Mr. It's not please without to withdraw innocent contempt application. We'll have to file a fresh one impeding the correct respondent.
Lordship. What's plus lordship?
7.
Yes, Mr. Jha.
Mr. Jha is not about the matter. Has the grievance has been addressed to.
Where is Mr. Jha?
I didn't see him. Otherwise, the matter could have been closed.
Who's with Mr. Jha? No.
No one is here.
M. Jha, R. Jha. What is the matter about?
This is with regard to dismissal from service. Because the petitioner, what he did, well, he tried to commit suicide. Well, he's an Assam rifle person. So he was charged under court martial. And now we have recalled that order, well, the dismissal order.
Let's see it slowly. First one. Yes, Mr. Jha, what is wrong with you?
No, my lord, sorry.
The impugn order has been withdrawn. You aware of that?
No, this one.
Give him a copy. You've been instated in service since 17 October 2024. This was filed on?
Filed the month of March.
How is this possible? Yes, the learned Dr. Nitish Muzika, NTSGI, has today produced a letter dated 9/5/2025 issued by the respondents, showing that the order stated to be impugned in the incident writ petition, which concerns the dismissal of the writ petition from service, has already been withdrawn, and the writ petitioner has been reinstated to service by an order dated 17/10/2024. Stop. Mr. R. Jha, learned counsel of the petitioner, prays are allowed to obtain specific instructions. Release after 1 week. You call your client. Copy of the communication is taken on board. It's been withdrawn. It's been withdrawn since last year, and it's been reinstated into service on 17th October.
Definitely, my lord, why he will be perusing this matter if he has been reinstated in service?
No, he has some ego problem. Right? He said he will see in court.
It's unfair submission.
That's what I've
DSGI.
We'll close it.
No, my lord. It's when, my lord. When this order, why yesterday also I received from him.
He's not been reinstated.
No, my lord.
Then what? Then this order has no meaning.
It's just to.
But see, the order's been is dated since last year.
Order
Discipline
dated
force
11
can't. You can't expect that. You take instructions.
My lord.
You join also.
He has not joined, my lord.
He's not joined. You go and join.
In fact, some direction is required to.
No, let him come. Instructions.
My lord.
We'll have it. Today's Wednesday. Thursday.
Wednesday, my lord. Thursday.
Monday.
Monday.
Yes.
My lord.
What he's serving as what? Havaldar clerk.
No, my lord. It's a Havaldar head counsel. Havaldar GD.
Constable.
Item number 8.
We have filed the
Lordship, a paper has been filed, Lordship. 2 weeks time may be granted, Lordship, to file their rejoinder.
Lordship, may I take you to, they have filed the one private respondent of the petitioner have filed the additional affidavit to bring on report subject document. This is defect. May I just draw your attention, Your Lordship, the affidavit which they have filed, Your Lordship. Additional affidavit.
Who has filed the state?
Petitioner.
Petitioner.
What is the
No, they have. It's there, I think it's on record. May I take you to the page 8 of the additional affidavit, Lordship. Page 8. Now this is the now said that in the apartment para 3 of the additional affidavit, they have stated that we have forcibly taken the signature of the petitioner, then we have withdrawn. That was the allegation, Lordship. Now may I take you to para 3 of the additional affidavit, which is at page 2. Para 2, they have mentioned, Your Lordship. May I just read it, Your Lordship. that the deponent petitioner begged to submit that Sri Belson Moment, job card holder, and other come to the resident.
Where are you reading from?
The additional affidavit filed by yes, the para 2, not the para 2, it's page 2. It's para 3.
Then yes,
Lordship. Yes.
We have not received a copy of this additional.
You have not given copy to the state. No, what do you want to say?
No. Here is saying that since one of the job card holders has taken the signature forcefully, therefore they said that they have filed the FIR against me. Now, they, according to the document and the statement here, first they filed the FIR against me. Then only I have taken the signature forcefully from the petitioner. How can it be possible? If the allegation is true that first I have to take the signature forcibly.
Maybe they made a mistake with the dates.
No, it is. They have enclosed the document also, is the Lordship. See the withdrawal.
That's good. It'll work in your favor then.
What I'm trying to say is that they're.
Mr. Leonard Counsel petitioner prays that to the affidavit filed by the state. It's about 2 weeks' time to file the joint affidavit, as to his affidavit also, as well as the affidavit of the private respondent. Stop. Mr. P.T. Sangma, Leonard Counsel for respondents number 426.
Yes, Lordship.
Has submitted before the court that any additional affidavit filed by the petitioner to bring on further materials, there is a serious
FIR.
defect. Yes.
FIR and withdrawal.
Yes. The same shall be taken up at the time, the objection will be taken at the time of hearing.
Your Lordship.
Hello,
Yes, after 2 weeks. Case shall be considered at the time of hearing.
Item number 9.
Yes.
Yes. Lordship, I'll be withdrawing my engagement from this matter, Lordship, as SBI counsel.
This is the first time we had engaged yourself as SBI counsel. You withdrew from the state. It's the same matter.
No, Lordship. I was engaged as SBI counsel only, not for the state.
And this year now?
And now there appears to be a conflict of interest because the matter pertains to reservation. So I'll not be able to appear for the bank in this matter, Lordship.
So you won't appear in the matter at all?
I won't appear at all.
Yes. And then who will appear in your place?
So Lordship.
And State Bank, if you should notice.
Better, Lordship. I've sent them a letter also. At this juncture, Lordship, I pray that my name cease to be reflected on the cost list, along with my associate also.
Reflected as counsel appearing for respondent number 3.
Lordship.
Submits are due to conflict interest. Her name number 3. Her name may be, or she is withdrawing. Due to conflict, she is withdrawing herself from the instant matter. She further prays that her name be no longer reflected on the cause list. Prayers allowed. What about number 2?
I'm for number 2 state response.
Yes. You're filing affidavit?
We are waiting instruction.
Yes, sir. MS Arconi, on behalf of number 2 state subjects that instructions still awaited stuff. Next, as MS NG Shila has withdrawn herself from the. What about the respondent 1? You file affidavit?
The dispute primarily is with State Bank of India.
Okay.
The main respondent is the union, my lord, because it's their.
Okay, before that, Dr. Mbozika also prays for 2 weeks' time to obtain proper instructions. And last paragraph, as MS NG Shila has withdrawn herself to counsel number 3, petitioner take 5 steps for service of notice on spot number 3. Yes, this up to 2 weeks.
Apply, Lordship.
Item number 10.
The respondents are yet to
file. My lord, I'm for respondent number 1 and 2. I'm praying for just 1 week time to file my affidavit, my lord.
What is this, Miss Case?
My lord, they're challenging an advertisement by which...
So what Miss Case is this? This case number 69.
That is not in this case, my lord. It is in the other case, my lord.
In 69, this is which case?
Not with it.
Number 10, WPC 69, correct?
My lord.
Then miscase is in 69. What miscase is this?
Oh, Your Lordship, we have filed it yesterday. It's for the praying for the staying of the advertisement, Your Lordship. Yesterday's one. The new one.
You haven't given notice to them?
We have given, Lordship, yes.
My lord, so far as our instruction concerned, the entire recruitment is at the stage of interview now. And the petitioners, my lord, they have not cleared the very beginning, the preliminary examination only, my lord. Physical efficiency tests, they have not cleared. So the question of staying the advertisement when they themselves have never cleared will not arise, my lord. Moreover, my lord, the MPSC is conducting the entire recruitment, my lord. So I represent 1 and 2. I'm bringing 1 week time, my lord, to file my affidavit. They are at the stage of interview and they have not.
Your Lordship.
And my lord, this is 2000. It has started since 2019. Advertisement. 2020, my lord.
Started since?
The advertisement also, my lord, at
Since?
this stage. The advertisement of 2000.
The advertisement is of?
Advertisement, yes, stated. Which advertisement? Yes,
The two advertisements.
Because they have referred to
April
two, my lord.
2018, Lordship, and
Two advertisements.
29 September 2023.
Advertisements.
One is
19
18
September.
and one is 23. So now we are at the
In the
stage of
main case,
interview.
what is the stage of the main case?
As far
You
as
don't file affidavit till now.
My lord, this is a
Not
very
yet,
new
Lordship.
case, my lord. It's 2025. So I'm praying 1 week time, my lord. I'll be filing my affidavit. MPSC has to be also be represented.
First miscase. This is a miscase 82 2025 in the 69. An application filed by the petitioner for stay of the recruitment process, which was advertised by advertisements dated 13/04/2018, 29/09/2023, and 19/09/2024. Stop. MSR Kohli, next paragraph. Learned Counsel for the state respondents has submitted that the selection process at the interview stage, and there's no question of staying the proceedings, in as much as the writ petitioners themselves have failed to qualify in the written examinations.
My lord, they did not clear. They cleared only the preliminary stage. Thereafter, there was a physical efficiency test, which I'll be bringing in my affidavit, my lord.
Problem?
They have never reached the written exam stage, my lord.
And there's no question, and as such, there's no question of staying the process. Stop. She prays for allowed 1 week's time to
Lordship.
file objections.
It's not submission, Your Lordship.
Yeah.
Your Lordship, as far as Miss case is concerned, Your Lordship, can it take it after at the end of the board, Your Lordship?
Why?
At the end of the board, Your
Why
Lordship?
end of the board?
Because my senior will be there to satisfy the court, Your Lordship.
My lord,
They have to file their objections. Only in this case, it's only fair that they be given opportunity to put the objections on affidavit.
And moreover, my lord, they have not made the other candidates a party
Doesn't
also.
matter.
So this will not
they
be.
put objections, हम no? अब put तो. There's no question of staying the process now. She prays for allowed 1 week's time to file her objections. Yes, just a matter after 1 week for consideration of the instant this case. Stop. In the main case, try to file affidavit in
My
1
lord,
week.
I'll be filing in a week's time.
Yes, in
Affidavit
main case,
opposition.
MS Argon submits that affidavit file within a week. Yes, according to this.
For respondent 3, none appeared, Your Lordship.
3 is MPSC, my lord. They are the one who is conducting the entire recruitment.
MPSC, Your Lordship.
Well, on one of the occasion, Miss
They
B.
have
Kharwanlang has already entered
already
appear.
entered
So they have
appearance.
not appeared there
Don't
thereafter.
see her here.
They should be in a better position with regard to stage of the recruitment also, my lord.
The colleague.
Yes. Yes, in the main case, none appears as part number 3, though it is reported that MSB Khar Wanlang
Yes, Your Lordship.
had appeared on earlier occasion and stuff. MS Panjam submits that point number 3 is a vital party as much as they are conducting selection process. What should we do? We ask Secretary MPSC to appear in person. If they don't appear,
He's there, Your Lordship.
one of your colleagues will ask Secretary MPSC to appear in person. Then, if it is a second time non-appearance,
MPSC is a party.
We have not received any notice as of now, Lordship.
then why didn't you?
We take instructions, Lordship.
They have already entered appearance, Your Lordship, by
Yes,
dated 1st April 2025.
We have Kharwanlang.
And he's coming for the third time. First he appears,
Yes,
second.
stop. Today, Mr. S. Chanda present, he be allowed 1 week's time to obtain specific instructions. Stop. Ms. Arkolni also submits that after we filed within a week.
Madam.
According to this matter, after 1 week, together with Ms. Case number 82.
Item number 12.
In this case, I have just received a copy of the affidavit filed by the state.
We have filed this morning.
So I pray for 2 weeks' time, my lord. I'll need instruction.
Why 2 weeks' time?
Just now I have not even gone through. Could not even gone through.
Yes, Mr. S. Sen submits that as he just received the copy of the affidavit filed by the respondent, he requires 2 weeks' time to peruse the same to file join the if necessary. Stop. Prayer is allowed this up to 2 weeks.
There is an interim order, my lord.
Interim order for?
This is with regard to forcible taking over of Bijni complex. So lost him on the last occasion.
Interim order of any shall continue till next day.
Item 13.
Item number 13 to 26 are connected matter. And I appear for the state respondents, my lord. Number 2.
No, because this only contention is you are appearing for whom, Mr. Pandey? National Highway Authority?
For NHIDCL, respondent number 4 and 5.
So when are you filing affidavit?
My
Dr. Mozika is appearing 1, 3 and 5. 1, 3 and 5 you are appearing now.
No, Lord.
Who's appearing 1, 3 and 5?
Senior counsel appeared on the last occasion, my lord.
You are appearing for 4.
My lord.
4 and 5.
2 is state.
My lord, 2 and 6.
So all counsels represented now, that means. How long did you file affidavit? Mr. S. Pandey today has entered appearance. First appearance today.
Yes, Lord. I'm entering.
On behalf of respondent number
4 and 5, Lord. NHIDCL.
4 and 5.
4 and 5.
And praise have allowed how much time? 2 weeks' time to obtain instructions. Yes, sir. But Dr. Mozika, any from your side, any instructions?
My lord, the compensations claim under the National Highway Act, my lord, not LA, my lord, proceeding.
3, 4 and 5 you appear, Mr. Pandey.
One I will file affidavit.
Yes. Problem no? Mr. S. Pandey submits that he will be the counsel conducting the matter on behalf of respondents 3, 4 and 5.
Lordship, 4 and 5 entering appearance, Lordship. For 3, I have to take instruction, Lordship. So this the government of India, Lordship.
3 is you, not Director, Ministry of Transport. Doesn't matter, then it'll suffice then. Dr. Mozika, appearance 1 submits that no affidavit forthcoming from the said respondents. So what about state?
My lord, we are waiting instruction, my lord.
On behalf of respondents 2 and 6, Ms. Arkolni prays for about 2 weeks' time to obtain instructions file affidavit. This thereafter.
My lord, 13 to 26. This will be 13 to 26.
27.
You've taken steps.
Yes, Lordship, I have taken steps.
Yes. Yes. Where's the affidavit? What instruction is necessary? What instructions are you to get? Yes, MS Anne.
My Lord, as to why he hasn't yet been absorbed.
Yes?
My Lord, in the petition, he has stated that he has not been absorbed yet. Whether or not there were reasonable grounds for not absorbing, and as to the facts as well, we need to get instructions.
You haven't got instructions as yet?
No, my Lord.
MSS Anne Place was allowed further 2 weeks time of your instructions. List of 2 weeks for instructions and for service report and spot number.
5, Lordship.
5. Yeah.
5
and 6, only 5.
Only 5, Lordship.
28.
Please, this is that golf matter, It's the golf union matter. My friend has filed the objection,
Where's the objection? Is it record here?
We filed it yesterday. It should be on the record.
Okay, yes.
They're challenging the maintainability of this writ petition on certain grounds. So I can satisfy your lordships, we can proceed with the matter.
You ready today?
I'm ready.
Well, let's just see the objection.
If my lords have it.
Yeah. It's by the Indian, appearance of the Indian Golf Union.
For 2 and 3, my lord.
It's the Indian Golf Union.
Yes.
Yes.
And the other respondent is?
Union of India Millets.
No, but is there any element of
My lord.
national justice involved? Suppose you de-affiliate them, can you do that without hearing? You're not heard?
No, my lords.
My lord,
they admit that.
I'll come to that also.
See, the only thing is that, see, if you're objecting to maintainability on the ground of, it's a society and so on, but then like other aspects also, since it's a larger public interest also,
Lord,
or the golfers' interest.
My lord, I would humbly submit that would be more on the factual aspect of the matter, whether show cause notice was issued, etc. But to get to that point, my lord, the initial hurdle which petitioner will have to cross is the fact that, according to us, the petition itself is not maintainable. This would not be the correct forum for them to ventilate this particular kind of grievance, my lord. So, if lordship allows, I'll start, my lord.
You start, yes?
Yes. My lord,
one thing first, how many associations are there in Shillong? Playing in this?
There are
6. There are 6 associations.
There are 6 clubs. There are 6 clubs.
They are functioning.
6 functional clubs.
There are 6 clubs.
With their own members.
Yes. 6
Then
functional
what's the situation with the other clubs? They're not affiliated to anybody.
The other clubs are all 5 are with me, my lords.
Those are on the facts, my lord.
No. It's
yes,
just to get a
clubs,
larger picture now.
Altogether, there's 6 clubs.
Right. From what you understand is, you pay no cost, you pay green fees, correct?
Yes, my lord.
To use the course. Then you pay green fees. Then suppose you're affiliated to, you are a member of some club.
Yes.
You're seeing the 6 clubs.
Balance.
And IGU recognize which as other club?
IGU has now recognized, my lords, the Shillong Golfers Association.
Are they a party?
There is a concept.
No, they're not a party, my lords. Because I am not, my lords, on the issue of whether they've been recognized or not. I am only on the issue.
No, but they'll be affected. Suppose any orders come out that that to show that these.
That is actually one of my points, my lord. That is actually one of my points.
Here again, there is another difficulty, my lords, because what they now say, my lords, because a caveat had been filed. Now, if your lordships permit,
by Shillong Golfers Association.
My lords. No, by the Shillong Golfers Association, my lords, where they say that they were first affiliated and then we were de-affiliated.
Where's Shillong Golfers Association?
We've not made them a party because I'm not aggrieved by, my lords, their affiliation or not. I'm simply saying, my lords,
or not, it's not a necessary. They're a formal party. If they have been recognized, that means if any orders are passed, maybe suppose in your favor, they'll be affected.
If lordship looks at page 21 of my affidavit.
Yes, that is a serious.
Because Lordships,
whoever has any interest, sir.
my lords, if
Mr.
I may
Paul,
just take your Lordships to the impugned order first.
Page 21 of my affidavit. This is the letter, my lord, that was issued on the same date as the impugned letter, 28th of April. This is issued to Shillong Golfers Association. Para 2, my lord, we are pleased to inform you that Governing Council of so-and-so in the GC meeting held on so-and-so has approved the
so they have
affiliation.
impugned this also.
No, I have not.
No, I mean, Shillong Golfers Union,
Association.
Shillong Golfers Association, they are the affiliated club now, correct?
They say now, my lords, that they have been affiliated.
So the letter shows very clearly that they have been affiliated, rightly wrongly. I'm not on that, my lord. Now, simple fact of the matter is, my lord, with respect, Lordship may not be in a position to pass any order, interim or otherwise, because any order will affect them, my lord, and they are not before my lord.
That's the only concern. Yes, you start.
Okay.
If that is only the tentative. I mean, like, sorry, observation. Observation. Tentative. I mean, you've not made them party, and they'll be
because when we first came before your Lordships, my lords, our only grievance was my de-affiliation.
Right.
Subsequently, my lords,
the third party interest
now they came up with a letter saying that no, we've affiliated somebody else. Then? Now in the caveat, my lords, they say that they were first affiliated and then I was de-affiliated.
They say they were first affiliated.
Yes, my lords.
And now this is the same day. I think you have to previous parties, Mr. Paul.
I can file a application, my lords, making them a party, but essentially, my lords, the issue here is, my lords, we are only limited to this issue. That if I have to be de-affiliated, my lords, I have to be given an opportunity of being heard. That's my only case.
But they will have an issued maintainability also. Rightly or wrongly, whatever. Maybe the bulk of the battle will be carried by Mr. Jindal, but even then they are interested parties.
They're naturally interested, because
my learned friend will also have some difficulty.
You're already appearing?
No, I'm not.
Then how can you appear for two?
No, because there's no interest. Because Shillong Golfers Association is not a party here.
But caveat is there.
At one point.
Caveat is
fine. Caveat on behalf of
at one point,
caveat. Given a caveat.
So they are there.
We have a copy. My learned friend has filed a caveat.
Then that makes the situation a little bit
more complicated.
So this caveat, my lord, was filed on behalf of Shillong Golfers Association.
Your signatures here?
Yes, my lord. No, I'm not running away from it. So Shillong Golfers Association is not a party here, my lord.
But even then, there'll be conflict of interest, whether they are here before the court or not. But once you've handled the brief for them, now whether you can now sidestep the issue and come and.
It was only a caveat.
Mr. Jindal, I mean, this court does not look very kindly. I mean, like,
it was only a caveat, my lord. It was only a caveat.
Whatever it is, I am sorry. The court's sorry. I think you just clear your premises first, and then we will take up this matter. This is for the after tomorrow to allow the council for the
after tomorrow Saturday
or Monday to obtain specific instructions.
Lordship, can this come on Tuesday, my lord?
Tuesday, yes. But you better come clear, and otherwise.
My lord.
And in the meantime, also we will
file a short
application for objection to the. You want to reply? You
reply to the objections
file. Yes, we will file. Yes.
29.
May please, Lord.
Here the AG is leading us, Your Lordship.
Yes, Lord, in this matter, my Lord, the matter is kept for instruction, my Lord. In this case, my Lord, what has happened, my Lord, that there was a congregation of the church between 28th February to the 2nd March 2025.
There was a
congregation of the KGP Synod, Your Lordship, in Nongstoin.
So the work was completed for that purpose during that period by local contractors.
Or paid for by the church only?
A church, because it was a road which was
existing road, Your Lordship.
I have the instruction.
So, Mr. Longpur, it's not made by them.
May please, Your Lordship.
State government, Lord, on their request, my Lord. It is made by the state government through the local contractor on their request, my Lord. Kindly see, I have instruction with me, my Lord. Kindly see page annexer A, my Lord. Annexer A of my instruction, my Lord. and the work is also complete to the extent of, in some cases, more than 100%, my lord, because it was meant for that purpose only. Your lordship will kindly see annexure A of the instruction.
Where instructions?
Instructions have not been filed. He has not given it.
There are annexures, my lord. First, the annexure A, my lord. Kindly see annexure A. That this is in Khasi, my lord. In annexure B, your lordship is relevant one, my lord. With sir, your lordship has got annexure B with reference.
So
to
how do,
subject
like,
side
in situations like this, what is the what is the, you know,
certain
the procedure, what is the procedure adopted? What do you do? I mean,
we will file a detailed affidavit, my lord.
any
that,
church,
in very-
like anybody just request road be made, will be very good then. If I do the roads bad here, we just make a request and straight away is made.
No, I understand what is calling from your lordship, that there has to be some procedure in such cases of
Yes.
urgency where some urgent repair is required. In this case, what has happened, my lord, that there was an annual congregation and
Whatever
there
it
was
is.
a request, and the local contractors came forward even without sanctioning and without money, that to repair the roads for the purposes of the church. And that was done way back from November. This is the averment of the petitioner in their petition itself. That it was done, it started in November, because the congregation was to take place in the month of February and
Okay,
month of
Mr. Learned Advocate
I
General
filed a
today
detailed affidavit,
has come forth instructions and submits that the construction of the road was due to the congregation or church that was to be held where? Nongstoin. Nongstoin. So he prays aloud 2 weeks time to file a detailed affidavit.
Your Lordship, there's a miscase application filed for suspension of the work. Your Lordship,
Suspension
that
is
will
nearly
work
completed.
Your Lordship.
It's for public interest.
Work is already completed. In progress, Your Lordship. As per my instructions, still in progress. And this is a
For
new
the
road, Your
church, the
Lordship.
churches was when?
In February, Your Lordship, February and March. And
Any payment to the contractor or
no payment has
Your
been
Lordship,
made.
this
okay,
is
any
a fresh construction, Your Lordship.
No,
It's
it
a
is
new
not
link
fresh.
road, Your Lordship.
It's
It's not
fresh.
improvement, Your
Your
Lordship.
Lordship, we
It's
can
a
show
new
you the
link
chart.
road, Your
okay,
Lordship.
please just no.
At least if bills may not be allowed to be released, Your Lordship.
There are 9 contractors who have done their job without money,
He submits
and, my lord, and they have also not been made party, my lord, and they have done it for the purposes of public interest. There is no malafide. And now my friend is coming in March, my lord, sorry, in June, when the work is over, to stop their payment, whatever little
That's because of
payment,
the
9
sanction
companies
order
have
that's
done,
only been belatedly published, Your Lordship.
Okay.
That was issued
Okay, yes,
belatedly.
just okay, yes. Yes, what's the due to the congregation of no, due to the holding of a church function? Anta? Stop. MS T. Sutunga, on the other hand, submits that the work in question is still continuing, and she praised that the minister's application for stay of the implementation of the project be taken into consideration. Stop. Next, we are considering the fact that the construction of a road is for development and in public interest. No interim orders will be issued by this court for stopping the construction. However, on the merits of the case and the procedure adopted by the state respondents and allotting the work, the same shall be examined and be subject to final orders of this court. Yes.
Oblige, Your Lordship.
Yes.
Hearing 36.
Yes, You are agreeable?
My lord, I am only the authority who has decided the matter, my lord. It is the private person.
It's okay, my lord. It's a family matter.
Yes, it's submitted by the councils that the matter concerns a internal family dispute with regard to some landed property. They fairly submit that it would be better served if the matter is first taken up for mediation. Like paragraph heard on the submission of council parties on and considering the fact that the same concerns an internal family matter. The matter stands referred to the mediation committee for appointment of scheduled mediator, who shall inform the dates accordingly. Yes.
Your Lordship, the record will have to be sent there.
The records have been called.
Record is with me, my lord.
Records, because this records will be needed.
The mediation committee, as and when shall request
place
for the
it,
records from the statutory authority. Yes.
No, the record is already with me, my lord. I will place it whenever it is
Give
needed.
registry. Yes.
My lord.
You can do one thing. The records you submitted now. Mr. SD has also submitted the records with regard to the land documents to the registry to be placed for the mediation committee. And one plank.
Second call, item number 3.
Please, your lordships. No, my lord, the only issue remains here, your lordships. On the factual part, we have made our submission, my lord. Only issue remains, my lord.
Clear a doubt on the court.
19, emergency clause. 19, my lord, speaks about, my lord, appointment of an administrator, and that will lead to suspension, my lord, deemed suspension. The provision provides for, my lord, deemed suspension. No order is required to be passed by operation of law, my lord. Once an administrator is appointed, my lord, the sitting chief will be placed under suspension. That is the, my lord.
No, that it implies that.
That implies.
But whether that temporary provision
lordship
will not result in dismissal or removal,
lordship,
or any other proceeding. Like once the deadlock has been removed, then the person's put back in place. Does it imply that?
No, my lord.
That's the only thing.
My lordship will, again, my lord, cost of repetition, I'll take my lord to section 19. Lordship will kindly note the language used in section 19.
I'm not sure.
Emergency provision in case of, notwithstanding anything contained in this act.
Yes.
Now, my lord, this is independent of.
Non-obstance clause.
My lord, this is, my lord, this is what it say, in spite of, my lord, other way if I can put in, my lord, the authority is free to take action as well, my lord, under other provision of the act. So that will not, my lord, here what is the core consideration, my lord, whether there is a deadlock.
Yes.
Whether the chief is in a position to function.
Yes.
That is the only thing.
So deadlock you already said
yes,
that
yes,
there's a deadlock.
yes, my lord.
So, but whether the way taken by the impugn order is correct or not.
Lordship, my lord. So my humble submission, my lord, this is independent of other provision, my lord. It has not ousted, my lord, the authority from taking recourse to such action which is provided in other provision of the act.
Yes.
My lord. And lordship will take note here, if, my lord, the recourse is taken only in section 19, only in section 19, not in other provision of the act, then obviously it follows, my lord, an administrator is appointed, that is good enough, my lord.
Yes.
That follows by deemed suspension. By operation of law, he will be placed under suspension. Here, my lord has taken note of, I think lordship has taken note of the impugn order. It says there is a deadlock. Second part of the impugn order say, he is placed under suspension pending inquiry. That is categorically provided. Obviously, my lord, that power is not available under 19.
Yes.
That obviously has been taken under some other provision. Now, what is that provision? I'll take my lord to that provision. That is, my lord, 6. Section 6.
Yes.
If I can read, my lord. The chief may be removed from his office or suspended by the executive committee if in its opinion, my lord, these are the numerous ground, my lord. Here we are concerned with I. He has lost the confidence of majority of his electors or the people of the Elaka. That is a ground for suspension. Now, my lord, these very provision contemplate two kinds of suspension. One suspension by way of punishment.
Yes.
Other suspension, my lord, pending inquiry. And it is very categorical. I'll take my lord to that. You say if it is suspension by way of punishment, he has to be afforded all opportunities.
Yes.
If it is pending inquiry, my lord, that opportunity is not required. That is clearly, if your lordship come to the bottom of this section, my lord, the provisos, there are three provisos. First proviso is provided that every case, such case shall be placed before the council in its next section. Second proviso, my lord, provided further that no chief shall be removed from office or punished with suspension.
Yes.
Unless he is given an opportunity of being heard. That is very clear and categorical. Cannot be removed, cannot be placed under suspension by way of punishment without affording it. Now, my lord, it is important, the third proviso. Provided further that requirement of second proviso above shall not apply. That is affording an opportunity. Number one, in case where the order of removal or punishment or suspension is awarded on account of his being convicted, and this will not apply. Two, in case of order of suspension pending inquiry. Here this is not required at all. Now what happened in this case? Obviously, my lord, this suspension pending inquiry is under these provisions, though the district council has not quoted any provision. Now what will be the consequences, my lord? I will rely on some judgment. What is the consequences if a wrong provision is quoted and if no provision is quoted? It is the duty of the court will look into the entire act and ascertain whether there is a source of power, my lord, to do this act. That is all. So
yeah,
my humble...
Exactly. You put it very well. And a source of power, whether it is only an action under section 19 or it has brought in the provisions of of other provisions of the act to, you know,
my humble submission, it has
justify your impugn order. That's the only thing.
Yes. Now, my lord, here, my lord, he admittedly, my lord, he has been placed under suspension. Then there were allegations, there were loss of confidence. Both these things were clear and categorical. And the district council, my lord, after relying on the materials in record, after some kind of hearing, my lord, they have ascertained and came to the finding there is a deadlock. So they have taken, my lord, action, two-pronged action, placed him under suspensions, and because of the deadlock, administrator was appointed. Had it been, my lord, solely an action taken under 19, my lord, there was no requirement of separate...
Last time, I think Mr. Marpan's argument is that it's specifically under 19 only, that the district council reserved only 19.
The measures taken are under 19 later.
That is what? See, he's reiterating that. That's under 19.
But it's also, this is a composite order.
Now he's saying composite order.
So,
no, it's okay, yes. No, let him complete, yes.
So, my lord, this is the thing. Now, my lord, obviously, my lord, when there is a loss of confidence
so
of
the power section 6.
Lordship, 6.
And like, you know, and
provisions.
Is 6 plus 19.
Lordship.
Yes, okay.
Now, my lord, 19 as it clearly says, this is independent of any other action under any other provisions. Well, it has not, my lord, prohibited the authority that if action taken under 19, some other action cannot be resorted to under some other provision, my lord. That is very clear and categorical.
Notwithstanding anything contained in the act. Notwithstanding any other action taken under the act.
Exactly. Right? Exactly, my lord. So this is not barring any other action under any other provisions. It is not saying that if you take action of my lord, appointing an administrator, you cannot take action under other provisions. That is very clear and categorical. Now, my lord, here, my lord, if your lordship, my lord, look into the impugn order, my lord, very clear. They have done a fair kind of assessment, my lord, heard the parties. A number of, my lord, complaints were looked into written arguments. Now, my learned friend's submission is that entire endeavor on part of these lindos, my lord, whom I am representing, just to reopen, my lord, what has been concluded in the first inquiry. But that's not correct. As I have pointed out, my lord, on 27 September, a written argument was also filed. And in the written argument, my lord, categorically you have narrated certain incidents which took place after his reinstatement, my lord, following the conclusion of the first inquiry. Now, those were before the authorities, my lord. They looked into it. Thereafter, they looked into the written argument filed by the writ petitioner also and came to a finding, my lord. Now, here your lordship will appreciate one thing, my lord. As I said, my lord, this is not a final inquiry, my lord. Final inquiry is pending. Now, whatever complaint he has before this court, my lord, it is open for him, my lord, to go before the district council and agitate it. Now, my lord, regarding this some decision, my lord, regarding my lord wrong quotation, what endeavour of the court should be always, my lord, to see under the scheme of the act, my lord, whether the authority is empowered to take the action or not. That is the. So even then, my lord, I am not relying on too many decisions, I mean, two decisions, my lord. Para, that is 2007.
You given the list, Mr. Sir?
You have given?
You given the list?
The copies are here, my lord.
Yes. That is
2007.
Very interesting point, man. Very interesting point.
2007, 13 SCC.
Yes.
Page 255, my lord. Relevant paragraph is paragraph 18 and 19.
Yes.
If I can read, my lord.
Yes.
The order of discharge of the appellant from army service has been passed by the competent authority under section 22 of the Army Act, read with 13 on the grounds covered under column such and such of the table, after affording adequate opportunity to him showing cause before the said order of discharge came to be passed. We are, however, satisfied on the material placed before us that the court of inquiry was formed under Rule 177 of the Army Rule, and the purpose of the court inquiry was to collect evidence for information of superior officer and make up their mind about the involvement of the appellant and the other army officials in the racket of clandestine sale of petrol. In the course of inquiry, the appellant was heard and was given proper and adequate opportunity to cross-examine the witnesses, which he did not choose to avail. The respondent in paragraph 20 of the counter affidavit filed in opposition in the writ petition before the High Court have made categorical statement that in the court of inquiry, the appellant was given full opportunity to defend his case and to cross-examine the witnesses who appeared, and 19 is important. As noticed above, the appellant had shown cause by reply dated such and such issued to him by respondent number 6. The competent authority considered the reply of the appellant in the right perspective and found the same not so. Therefore, on such and such, the competent authority passed the order of discharge of the appellant from the army service with immediate effect in exercise of the power under section 20 of the Army Act. It appears that the competent authority has wrongly quoted section 20 in the order of discharge, whereas in fact the order of discharge has to be read having been passed under section 22 of the Army Act. Now, it is well settled that if any authority has a power under the law, merely because exercising that power, the source of power is not specifically referred to, or a reference is made to a wrong provision of law, that by itself does not vitiate the exercise of the power, so long as the power does exist and can be traced to a source available in the law. This is exactly, my lord, this exactly covered this case, my lord. Here the authority is available, my lord. Though, my lord, in the imping word, I admit, my lord, they have not quoted, my lord, the sections. They have the power, your lordship, under 6, suspension pending inquiry because of loss of confidence. And they have come to a prima facie finding that there is a loss of confidence. Then there is a requirement of, my lord, appointment of an administrative officer. Now they have taken recourse to 19, my lord. So my humble submission, my lord, this is as per the provision of the law, my lord, after giving him fair opportunities. Now, if he has any
application of section, you mean?
Yes, my lord, because they have not, my lord. Admittedly, impugn order has not referred to any sections. Now, only thing your lordship will see, my lord, whether the authority has the power under this particular act of the district council to take such a decision. My humble submission, as I have pointed out, my lord, 6.1 proviso, it is very clear and categorical. Appointment of an administrator in case of a deadlock, my lord, that is very clear in section 19. And so far, my lord, I will not repeat, my lord, loss of confidence, my lord, this is very clear and categorical. They cannot go back. Even in the earlier inquiry report, my lord, they have admitted the fact that there are 10 electors. And out of the 10, my lord, 5 are before your lordships. You have lost confidence in it. So, my lord, coming to, my lord, now, my lord, coming to, my lord, other submission of my learned friend, you made the other day, that we were the fancier in the first proceeding, we have never participated. I mean, this is wrong. We have filed an affidavit, my lord, The first, my lord, the first inquiry, my lord, there were certain allegations plus loss of confidence of the elector. So for loss of confidence, my lord, that issue was never decided in the first, my lord, inquiry. Had it been decided, my lord, matter would have ended there. That was wide open.
It was a point inquiry, he didn't participate. Okay, we
No,
overlook
my
the
lord.
fact. Even
Other reason I have stated categorically in my affidavit. Now, pursuant to the inquiry, my lord, they frame charges. We asked for furnishing of the copy of charges. Copy of charges were never issued to us. So we are seriously handicapped, my lord, to effectively participate in the proceeding. This was the reason. And even after that, my lord, the district council has filed the inquiry report. I have taken, my lord, that issue of loss of confidence by the elector, of the electors, never discussed. What was discussed, my lord? Of the clan. They have seen the clan members have full confidence, but admittedly, my lord, he was elected unopposed by the electors. So that issue was never discussed. So, my lord, here is a case, my lord, it's a matter of loss of confidence. Is a case of, my lord, certain allegation, my lord, pending inquiry. Inquiry is pending, my lord. He gets ample opportunity, my lord, including, my lord, whether the district council at this point of time, my lord, to go back and reopen the allegation made in the first inquiry. Plus, my lord, the fresh allegations are there. Now, he has to file a statement of defense, take his evidence, face it before the district council, not before this honorable court, my humble submission. My humble submission.
Only that because last time we were ready to pass the order, only thing is that clarification with regard to whether you took action as section 19, which does not envisage or contemplate any action that you've taken.
Of course, my lord.
So now your submission is that we only have to examine whether under the whole scheme of the act, whether the council has a source of power to pass impugn order.
Exactly.
That's all. Yes.
Exactly, man.
Master Marpan, anything to say? No.
Yes, Archie. I just want to clarify. Now, section 6, again, Archie, I would like to bring stress it on section 6. Like I said, Archie, this is a composite order. I've had a discussion with the EC and they said it's a composite order. Now, we have taken careful consideration in trying to make sure that section 6 is invoked in a proper manner. Archie. And you see the order, Archie. This is also enclosed with the affidavit in opposition by the respondent number 5. That is at page 35, Lodge. It's in fact enclosed the other miss case also, but this one, Lodge. Page 35 of the affidavit in opposition of the respondent number 5.
Yes.
No, right is 35.
Yes.
Now the order starts by saying the matter came up for consideration before the executive committee in response to the petition filed with the Lingdor right.
Yes.
Right after that, Lingdor right in bracket electors.
Yes.
Why they have mentioned in bracket electors? The reason being, section 6 speaks about loss of confidence of electors. Now, again, it goes on by Longsan Mangsan of the Nongpo Sadaship against one Prang CM, and these are para number 1 regarding the allegation against him, and also towards the in the observation para number 3 also. Again here, the observation made in observation A. Shri one Prang CM was sorry, as was reinstated as Sadar of Nongpo Sadaship by notification data. However, it has been evident from the numerous petition and representation by the Lingdor Rai. Again in bracket electors, and the Longsan Mansan of the Nongpo Sadaship that the Sadar has failed to gain the confidence of the electors.
So you see, cutting it short, that is a mix of section 6 and 19.
6 and 19.
And in para 4, the first part is section 6 and para 5 is 19 upon administrator.
Yes, because the observation was made in 3 that they have lost the confidence of the electors. The measures taken are 19.
Okay.
Yes,
Mr. Nupur.
Yes, sir.
That's got it. Yes, composite.
It's a composite.
Yes. 6 plus 19.
Yes, sir.
Yes.
Lordship, the impugn order is heavily defended by the private respondent, but not by district council.
It is in their interest, yes.
But section 19, Lordship, it starts with notwithstanding anything contained in the Act, Lordship.
Yes.
Now, the submission is that, Lordship, the impugn order is purely based on section 19. Had it been section 6, Your Lordship, had it been section 6, section 6 pertains to removal and suspension of the chief, Lordship. Had it been Section 6, Your Lordship, they could have appointed an acting chief under Section 11, Your Lordship.
Yes.
Had it been a case of suspension pending inquiry under Section 6 that he has lost confidence of the elector, Your Lordship, they could have taken another step, Your Lordship, and appoint an acting chief under Section 11. Because Section 11 says, Lordship, can you come to Section 11, Lordship?
Yes.
If at any time the post of a chief becomes vacant as a result of death, resignation, expiry of tenure of office, removal, or the chief is under suspension, the executive committee may, by order in writing, appoint the deputy chief or any Khasi male adult belonging to the customary ruling clan of the Ilaka and or is a native of the Ilaka concerned to act as an acting chief, who shall exercise all the powers and function of the chief. So the impugn order is not based on Section 6 or 19, Lordship. It's based purely on Section 19. Had it been based on Section 6, they would have appointed an acting chief, not an administrative officer, Lordship. And Section 19 specifically says that if the chief has lost the confidence of the Dorbar, Lordship, then an administrator has to be appointed, and the chief should be placed under deemed suspension.
Yes.
So, Lordship,
so for your submissions, it's purely action of Section 19.
Section 19, Lordship.
It does not envisage
inquiry.
Suspension per inquiry. Yes.
Lordship.
Yes.
And second submission is that, Lordship, Section 19 is very clear, Lordship. If the chief has lost the confidence of the Darbar, Lordship. Now I have taken your Lordship to my rejoinder at page 14. Who are those Darbar, Lordship? What constitutes the Darbar? The 12 members, Lordship. So in my submission is that the chief till date has not lost the confidence of the Darbar.
Yes.
So even on that count, Lordship, the recourse taken by the District Council under Section 19 to pass the impugn order is not valid at all. So there is no ground for taking any recourse or action under Section 19 because I still have the confidence of the members of the Darbar till date. So page 14 of my rejoinder, Lordship, is the list of the executive members of the Darbar.
Okay. So only one thing, then you better just give yours on this point, rather just on small notes and submission. That's the only thing. Because it's a purely point of law.
Your Lordship, I would like to reply regarding the section, page number 14 of the rejoinder, the list of the executive Darbar and Darbar Hima. These are presently, not all of them are still functioning. Some of them have expired also, and some of them are also against the petitioner. And it's in fact part of the record where at the time he was elected, two of them, I can just point it out specifically.
Whatever Mr. Ramkul submitted, that there is disconnect and there's a deadlock, that is apparent.
Yes.
Or there's no dispute.
Yes.
If there's no,
Exactly.
only thing is that, and if the electors are to take a call again, and if there's a deadlock, so
because why?
The only thing that whether action taken is the
one thing
any clarity in the process which has been adopted by the District Council in initiating, I mean in passing impugn order, rather. That's all.
One more thing,
Lordship,
the charges.
One more submission, Lordship. The entire premise of passing the impugn order is based on that written argument, Lordship, of 27 September 2024.
And also,
which I'm not.
The charges number 6 was a loss of confidence of the Kur. It has never been with the electors. The new charges when the loss of confidence of the elector.
Take recourse to that.
Loss of confidence of the elector. Now the previous charge has already been deliberated in the inquiry. It's already been inquired upon. They have found that there's no loss of confidence in the Kur and the clan. Never been with the electors. Now, that's a two different thing.
Yes. Just make a small submission, then.
Yes, actually, may be allowed to just give a current status of the page number 14, which they have enclosed.
We'll also
is the list of the Darbar. These are the presently they are not functioning. Some of them are not functioning. Some of them are passed.
There'll be no added. It doesn't matter. Just you give a small note on your submission on this point.
Yes.
We'll give it when? By tomorrow?
Monday. By Monday.
By Monday.
Only small clarification. My learned friend is saying suspension. This has to have been followed by appointment of a acting chief. Lordship will see the language. Here, my lord, appointment of an acting chief came, my lord, where this man has been finally ousted from the office. This is very clear. So my
suspension
this will not apply. Anyway, I'll submit a note.
Yes, so a small note. Only thing is that because the court has a mind also with regard to.
If they do not have the power.
Chew under Section 19 myself also. That's why I'm saying like, okay,
if they do not have any source of power, my lord, under this act, doesn't matter.
Very interesting point. Very interesting. Actually, these acts and restriction also throws up, something new.
But only
So
thing
I
I
keep
know-
on saying that, even though you might be doing many cases schedule, most of the areas will grey.
But the only thing, yes, exactly, Your Lordship. I try to find out.
Because
This
even
issue I
see, it's
never
a 1959
discussed,
act.
Never decided.
Like even then, 59 acts, the lacuna is there.
Exactly.
That's lacuna is there.
Many
So
of the
then,
issues, my lord-
and so it has to be by
Exactly,
intervention of
exactly.
courts.
Only thing, my lord, my concern, my lord, the man, he is functioning, my lord, single-handedly without Lordship Lordship is better aware than me, Your Lord. What is happening there? So this is a case, my lord.
No, we're not aware of anything.
Without losing the confidence of the elector, my lord, what it means.
Yes.
Hearing?
Hello.
Monday, let's submit on Monday for filing of
notes.
bullet points.
This is only for filing the notes, my lord.
Bullet points, yes.
Bullet points.
30.
I don't want written arguments now.
Hello. I'm being led by senior counsel.
Just give it 2 minutes. I'll just come back. 2 minutes.
Job ఉందంటే
Yes.
Senior counsel is on Lex Lordship. Division bench. And secondly, Lordship,
Yeah.
Lordship, the other matter which is connected to these items, 32?
30,
32,
31,
Lordship,
32.
Mr. Shilla is appearing in that matter. He's on
Who's
leave.
Mr. Shilla?
Mr. J. Shilla, Lordship.
Where is he? He's sick.
He's on leave, Lordship. He's on medical.
Then what to do? You make up your minds. We'll post it some other date.
After 2 weeks, Lordship.
Yes?
After 2 weeks.
After 2 weeks also.
Okay, on the request of the council of the parties, this matter after 2 weeks.
2 weeks.
Along with connected matters.
Lordship.
30, 31 and 32, your lordship.
37 also.
37 also.
And 37. Highly obliged.
Apply, your lordship.
33.
Please, your lordship. Lordship, the conducting counsel, Mr. H. Khawanang, he is on next before courtroom number 1, my lord.
In this case, Lordship, what I pray, Lordship, there are two things in this. Here, Lordship, my source of appointment was compassionate.
See, what is the matter about?
This is I was appointed.
Teacher matter?
No, Lordship. Here I was appointed on a compassionate ground, Lordship. In the year 2004, Lordship. 4th grade employee, Lordship. Grade 4 employee.
2003.
2004, Lordship.
While a scheme was in place.
Yes, Lordship.
Yes.
Then what happened, Lordship, all throughout my post was not regularized. Then 2018 I come to the High Court saying that please. 2018.
18, okay.
Then my post was regularized, but prospective regularization was given, Lordship. But all throughout, till today, Lordship, I am subscribing the GPF, Lordship. My Lord is well aware that GPF is only for government servant, Lordship. Now, 2000...
You given increments also?
Increment, Lordship, yes.
Promotion also?
Yes, promotion, no, Lordship. Now in 2021, they made a gradation list. And in the gradation list, I found that my serial number is below. And my juniors were above me, Lordship. Now, when I inquired that, because since my regularization was given on prospective, Lordship, then I will not be governed by the old pension scheme. I will be governed by the new pension scheme, Lordship. Now, because of the prospective regularization, Lordship, I am affected. With regard to my pay, parity.
What to do? He is Mr. Palas.
Lordship is
and Mr. Chandraja handicapped.
Yes, Lordship.
You have the brief with you?
Lordship.
Any other, no, Lordship.
Here, still in service?
Yeah, I mean.
How he's working as what?
He's a Lordship.
He was appointed as what in commercial ground? Which 4th grade post?
Yes, Lordship. Attendant, office attendant, Lordship.
Yes,
now, what they are saying that my appointment was not based on compassionate grounds. If my Lord can...
No, we'll overcome that. Due to unavailability of
Yes.
the arguing counsel on
Lord.
behalf of the respondents. When?
In after 2 weeks then.
2 weeks. Yes, after 2 weeks. Yes.
Team Leon.
34.
Lordship of, please, your Lordship.
Where's the affidavit?
Affidavit's already.
You got it, Mr. Shulai?
I don't
You
think I
agreeable
have.
to it?
It's already.
Yes, filed yesterday.
No, day before.
Exact.
Have you saved a copy?
That means total amount how much?
Total amount including interest is
Very less.
Yes, Lordship. In fact, should be more.
Only 2,80,000 only.
No, Lordship. The interest at page 11, Your Lordship. Along with interest, 3,49,000.
Or the additional affidavit?
Yes. Page 4, para 11, Your Lordship. Page 4, para 11. Total amount.
Additional affidavit been filed by the learned counsel of the petitioner, placing on record the total amount due to the petitioner from the respondent's central authority.
Your Lordship, I'm praying for some time to obtain instruction.
No, of course, that's what which as reflected in the at para 11 thereof Yes, an amount of rupees 3,49,819. 1 week will give you time. Yes, this after 1 week to allow the respondents come with final instructions. You pay him if you harass him enough.
35.
We'll issue directions. You will have to pay him the amount. Yes. So just an observation.
Apply, Your Lordship.
This case, Lordship, I received the instruction, Lordship, that teachers were shifted to other school, Lordship. The school is no longer exist, Lordship. So I'll just withdraw, Lordship, because.
Yes, my lord.
How can it be transferred school doesn't exist anyway?
My lord, because there's a policy, there's a government order in schools where there is no students, my lord. Those teachers were shifted to other schools, my lord, where students
So
are.
they give the same policy where there are many students, only one teacher.
No, Lordship, that is they have not followed.
They should have.
Yes.
You know, at Vidwan, when we have this program,
Sanctioned teacher of
we've gone to one place, a remote place, and in one classroom, which is, maybe, just where you are standing, just from there to there.
There are many, Lordship, yes.
One teacher teaching
so many
class 1 to class 5 in the same room at the same time.
The government should look after and
there are, Lordship, still.
some kind of
How do you
measures.
teach? He said, no, I told those do other work, he'll teach class 1 first and class 2. And the result is that some class 2 students are better than class 5 students. They're answering the questions of those class 5 students. But in the same room, very sad. And that's just in jest, but that's really happening.
Yes, ma'am.
Mr. S.A. Sheikh submits instructions that they may be allowed to withdraw the application. Seem objected to by counsel with the respondents. Matter stands closed on withdrawal.
Hello.
38.
Yes.
I appear for the respondent corporation, Your Lordship.
We can't. Totally blank. Who's the
Because
counsel?
otherwise, in my respectful submission, Your Lordship, it would be infructuous for the reason that the
Infructuous.
tender, because the tender is of 2023.
Who's submitting? Can you just identify yourself? I'm actually seeing on a blank screen.
Your Lordship, Shauri Sahai. I'll just log in. Give me just 30 seconds. I'll just see.
Lordship,
Mr. Sai, I thought you're playing in a bigger league. We haven't seen you for a long time.
I have been following the court every day after the matters here. I see on YouTube. I follow the court daily.
Oh, I thought you're already in a bigger league, so no place for little league is.
Always a privilege to appear for your Lordship. I've just been looking for the opportunity to.
Okay. Yes. Only thing is that the senior counsel is not here.
As your Lordship pleases, as your Lordship.
Then after 1 week.
Lordship. Yes,
Prayers me on behalf of, and you're not visible also, on behalf
Yes,
of the
yes,
writ petitioner that for some accommodation due to absence of the arguments in the council just after 1 week. Yes.
40.
Alwan. Jangan. Where's Mr. Yubin? What happened to Supreme Court?
My lord, that matter is dismissed.
Dismissed?
Dismissed.
Oh, then?
And there was a on the
Where's the order?
My lord, in fact, on the last day when the contempt matter came up, we submitted the contempt was disposed of based on that order.
No, where's what matters Mr. Yubin in?
Can be taken after some time. Can be taken after.
We'll take it on Monday. Yes, it's not so urgent. It's been submitted by Mr. A. Khan that the matter has since been disposed of by the Honorable Supreme Court. Yes, however, do you absent Mr. Yubin, who's the answering respondent?
Lordship.
Main answering respondent is the matter on Monday.
Apply, Your Lordship.
We'll finish it on Monday, Mr. Khan.
My lord.
41.
May it please your lordship. Your lordship, in this matter, we're supposed to file additional affidavit. No, your lordship, I'm praying for some more time.
MS Mirchang submits that though this court by order dated 23/4/2025 had allowed the prayer for filing of additional affidavit by the respondents due to unavoidable circumstances. The same cannot be filed today. We're recording this because in the hearing list already she prays for and is allowed
2 weeks time.
for the 2 weeks time.
My lord, the rejoinder also.
Shall continue.
My lord, the rejoinder also is not yet filed. My lord, I am praying.
Why you not file rejoinder?
My lord, we are awaiting
No,
the.
that will pass orders later on.
My lord, the interim order may kindly be extended. My lord.
Interim order shall I extend.
Highly.
Now they are saying that
The survey
it
has
falls
been
outside.
done, my lord.
It falls outside the. That's what they're saying.
No, they on last occasion they said that we fall under the defense land.
Okay.
41, 42.
Yes, Mr. P.T. Sam.
Yeah, please, Lordship. This matter was heard earlier on the last occasion. There is an order, Your Lordship. Just the respondent's counsel is supposed to give the status of the pension.
Where's the?
This is the
no,
order.
both of you.
This.
Yes.
The order dated 23/4/2025. It is stated that directed to obtain the appropriate instruction as to the status of the pension payment to the petitioner. That was there actually after hearing at length, because that was a completion, because they're supposed to bring the appropriate instruction.
Mr. Pan is appearing.
Lordship, from party, my lord, I'm appearing for respond number 1, my lord, for the state.
And secondly, my lord, there is a judgment where they have.
No, what's the judgment right now?
No, it is there because this is the judgment from the past from this honorable court only, and they have reflected and they said that that judgment is applicable to me. As per that judgment, Your Lordship, para 7, they are supposed to clear all the due within a
Now
period
this one,
of
who
1 year.
supplied this one last time?
Which one?
My lord, corporation.
Corporation. Now, what instructions have all you received? Your conflicting submissions have made last time.
In this matter, the instructions that I have received is that the monthly payment of the pension amount is being paid by the corporation on a monthly basis to the petitioner. And as far as the other retirement benefits is concerned, Your Lordship can see that the succession certificate is only in respect of the monthly payment of the pension amount. So it is not in respect of the other retirement benefits.
No, we are claiming only the monthly pension. In our pleading, we have stated we if any other due that we are not stressing on the other benefit. We are saying the monthly pension. It is their admission, Lordship. We are seeing the monthly paid since after the death of my mother. I have not received. My mother died on 18th December 2022. Our claim is from 18 2022, after the death of my mother, deceased mother. Our claim is that we have not received till death. What I clearly got the instruction from my the petitioner is that she has not been paid the monthly pension benefit, monthly only the family pension. Now we are not claiming for any other benefit. Of course, I have stated that if there is any due remaining besides the monthly pension, if they are stating that we are not disputing, but only my submission and the contention of the petitioner only that we are stressing is that we want that monthly pension only. No other due.
You already got the monthly pension.
No, we are.
See, as per the pension payment order by you in Annexure 4 itself, see, current pension enhanced rate sources being paid.
Which one, Your Lordship?
Page 16 of your petition. Then
16.
He's saying when we paid monthly pension, they're paying monthly pension. Then
no, this one, Your Lordship, page 16. The family pension as an enhanced rate, so and so, 71, so and so, with effect from 9/12/2022 up to 20/06/2005, 2025. We are saying we have not received this statement till now. If there is any payment, let them bring some sort of document to show that.
So Mr. Pandey is saying that receiving even the monthly pensions. That's the submissions.
Let them bring on a PDB. Let them bring on a PDB to show that they have paid any sort of document to before this court. Our concern is only this.
Muted.
So, Milord, I will again check with the department, Milord, as far as the monthly pension is concerned.
You're supposed to come today instructions as whether they paid up to date.
Yes, that was order was there. Yes, my lord, that I will come back to your lordship with that instruction, my lord. So
After
that
1
there is
week,
no
yes. Mr. S. Pandey prays for and allow 1 week's time to obtain up-to-date instructions with regard to the status of payment of monthly pension.
Yes.
Or the petitioner, yes.
Right.
After 1 week, yes. Please get, it's a pension matter, please get instructions.
Yes, yes, my lord, I appreciate it.
Yes.
43.
Obliged. Much obliged, lordship.
Wait, please, your lordship.
Yes, Mr. Kumar. Ready? You're muted.
I for the petitioner, yes, my lord. Matter leads to the last leg posting, my lord.
Yes.
I pray for accommodation, lordship. These
Mr.
guys
Dr.
on
Muzika's on legs. We'll have it next week. When's he retiring?
My lord, 1 year left, my lord, only.
Okay, we'll have it after 1 week, yes.
Highly obliged, lord.
Due to unavailability of Dr. N. Muzika, yes. All hearings just come to nothing.